Well, good afternoon, everybody. This is Jim Waszak from Success Enhancement and Kevin O'Flaherty, my co-host.
Hello.
With yet another edition of our Seize Your Business podcast. And today we have a returning guest, Tom Restko from Insurance Pro Group. Tom has been in insurance for a very long time, as you could tell by looking at him. And he knows everything there is to know. He knows more than most brokers have. He's forgotten more than most brokers actually know. But anyway, so our topic today is directors and officers liability. And Tom, welcome once again.
Thank you. Glad to be here.
Thanks for being here, Tom.
Yeah,
Thank you,
absolutely. So I think there's probably a lot of people, especially if they're younger companies just starting out, they maybe don't even have an idea what is directors and officers liability. So maybe you give them like a little basic
A quick synopsis?
synopsis. Yeah.
Well, there's two types, of course. One's for private enterprise, and the other one being for nonprofits. What person among us, if they have kids, haven't become a possibly something at the church, doing something on a committee at church, or doing something with the sports teams, where you're actually giving back a little of your time to help organize the events and things of this nature. That's all well and good, but the problem exists that if something were to happen, are you going to be brought into a suit? And that usually comes under directors and officers liability. There's a lot of different ways that this comes to be. You can have coverage, well, the policies themselves, excuse me. You can have coverage that covers the entity. You can have coverage that just covers a certain director. You can have coverage that covers all the directors individually. And you can have a package policy that covers both the entity and the individual people that are there volunteering, okay? So it's specific board coverage, and it's not something that is duplicated by any other policies, not your homeowner's policy, certainly not under your umbrella policy, your personal umbrella or even a business umbrella. This is a non-duplicated coverage that you really have to make sure that if you're joining any kind of group, that they have this kind of coverage in force. And the bad part about it, and I'm going to hurt my industry a little bit by saying this, but it is a non-standardized coverage, and I see too many brokers that sell it like it's an apples to apples situation, and it is not at all. And you must be very careful. I usually tell my own clients, you try to take care of the people that you have in other ways by, when you get into a group, I want to see that policy, okay? Because it's not standardized, and all innumerable ways they could be losing coverage or losing protection, and that they're hurt substantially.
So when you say standardized, you mean there's not like an industry norm of what it's supposed to cover, and everybody kind of writes their own version. Is that right?
That's correct, Jim.
Okay.
And not only is it that way, but it is kind of like a pick and choose situation. You can have coverage on the directors. For instance, if you're a director of a big company, okay, and this applies privately as well as for nonprofits.
Okay.
But on the private side, if you own a company, and quite honestly, a lot of companies, I would say 90% of the companies I go into that are private don't have this coverage, okay? And I really don't understand it. It's one of the quickest things that I get to sell them right away. It's a management liability policy, okay? And this pertains to you, it pertains to you. Again, not many companies get it because, quite honestly, brokers don't know enough about it, I think. But let's say that an employee leaves the firm and they feel that they were cut out in some way, or the firm starts to lose money and the company has to lay some people off. Let's say that you set parameters in your employee handbook and don't follow the parameters that you set. Or you never designed them in the first place, and the employee is upset that they weren't designed or were designed improperly. And you get a suit for any one of those situations. Unless you have a management liability policy, it's not covered by anything else.
So there's a couple different areas of liability. You know, when someone sues a corporation, they usually sue the corporation, and then
Right.
they sue all the directors and officers and just add them to the suit, settle everyone out individually if they can. But are these policies typically limited to rogue actions by directors and officers, or
No, it could be inaction. It could be no action whatsoever. It could be as simple as they see the background or the notes of the different groups, and they see that they didn't show up a number of times, so they didn't have the input. They can be sued for that. Now, where are you going to get the coverage? Nowhere.
Is there a limitation on it, though? Because, I mean, almost any bad act that a corporation could do is going to be based on its directors and officers. So I assume it's not like an umbrella policy for any malfeasance from the corporation.
It actually can be. It is kind of a catch-all, but it does depend on how it's presented. I mean, you know as well as I that if it's presented as a bodily injury case, well, that's not going to be covered under directors and officers liability policy. However, it will be covered under their general liability policy that covers bodily injury or property damage liability. But when it comes to something that you can't really put a hook on, and it comes back to a decision or non-decision that a board member could have made, then it's going to fall under that.
And
A lot of those, if it's not covered one way, a lot of attorneys will look at everything and, well, let's present it a different way so that we can get under the directors and officers liability. So.
And I know you said these are specially crafted policies, so I guess what I'm kind of going to try to dig into here is not what each individual type of policy might be like, but the scope of, you know, you tell me when we've hit the line where they'd never really cover that, even if you want to pay for it. You know, so, you know, for example, can you make it so that it covers both the personal liability of the directors and the liability of the company? Is that typically the way it's?
No, because again, what is it covering? General liability is going to cover, in the definition of what they're going to cover, bodily injury or property damage liability.
Oh, I'm not talking about that type of personal liability. I mean, like if a director, you know, makes a mistake or discriminates against an employee or something, will the policy cover both their legal fees and the company's legal fees, or does it just cover the company and the directors on their own to pay their own legal fees?
And excuse me, I'm going to go back a little bit.
Yeah.
It can be set up just to cover one particular director. It can be set up to cover all the directors together and individually. It can be set up with all the directors and the entity, if the entity is sued by itself. Okay, the board as a whole. So it depends on what you buy. Provisions that are different is that one can say that we are going to reimburse you for this type of claim. Okay, well, maybe that's not so good. I'd rather see verbiage that says we will pay on your behalf. Okay? And does that actually apply? Yes, there are some policies that are set up where we will reimburse you. So that puts the onus on the nonprofit corporation. All of a sudden, okay, where are we going to get this money to pay first and then get it back from the company? Believe it or not, those are current provisions in some of the policies that I can give to clients. Other things that could affect this is that defense costs. You know, defense costs can be unlimited, okay? Or they could be, in the policy, they could be limited to a certain amount. Or, worse still, the defense costs and what they can collect is under one provision, and it's set at $1 million. You know, defense costs can go over $1 million quite a bit.
Sure.
Okay, so
Not an O'Flaherty law, though.
no.
They start at $1 million. Right.
But once you hit that platform, then there's no coverage. So you might not even have coverage anymore on that kind of policy where the provision says that both defense costs and the penalty is covered together. So this is what I mean about not standardized, why you need to be very careful in what you buy. For that coverage, as well as a few others I can think of, it's almost you get what you pay for.
Sure.
Okay.
Yeah, so the more bells and whistles and the more covered you want to be, like any insurance, the more it's going to cost.
Yes, and we're still, this particular type of policy is governed by the application. Okay, so when filling out an application, I never let a client fill it out themselves. There are too many ways around it, and this may surprise you, I don't know. The first question on the application, name of the insured. Okay, so many people will do this. In fact, I went to one yesterday. They said such and such church. Okay, well, that wasn't their legal name, and they on their other policies would name their congregations. How should I say, like a parish, okay? It's not just one place, but it's a couple places. And they have loaned money, and they're under the auspices of that parish, I guess. I might be using the wrong
So
word.
it's like,
but-
in Catholic terms, it's like the Archdiocese of Chicago has a lot of
Exactly.
different
Okay,
churches.
so none of that was named on the policy. So if it's such and such and them for this exposure, and they just particularly just said this is such and such parish, and it's not even their legal name, what can happen, and I have seen it happen, is that they give the money back if they're looking at a big suit to the parish and say, we were not insuring this named insured, so we're not going to pay the claim. Because the application is a warranty to the coverage.
So let me ask you another question. A lot of times in companies' bylaws, there'll be an indemnification agreement where the company's going to cover the legal defense for the actions of the directors, but they'll usually carve out an exception to that for, fraud or breach of fiduciary duty or certain intentional,
Which is going to be on
criminal
the
action.
policy as well, but
Okay.
yes.
So, and that's what I was going to ask you. I assume you don't cover the company for the fraud or intentional acts of its directors. It's got to be ordinary course. I mean, there's intentional things like letting an employee go. That's an intentional act,
Yes.
but knowing malfeasance as opposed to just something that happens to be
And again,
around liability.
I can't really tell you how a policy will respond unless I'm looking at the policy.
So there might be
Okay.
policies out there that would even go that far and
Yes.
cover, director fraud.
Very definitely.
Okay.
Okay, and that's why you have to look at it. You can find policies that'll cover prior acts, like let's say the group didn't have any coverage before, but somebody all of a sudden said, hey, we need this coverage. Okay, call Tom Restko, he's great at this. So then I go out and then I find out, do they need prior acts coverage? And I can look for a contract that specifically includes their prior acts.
Wow, that's actually mind blowing to me because any sort of liability insurance will almost never cover prior acts.
I know.
Because how do you prevent then someone from saying, "Oh, we got a problem here, let's go get insurance"?
The application. The application will still ask whether or not you know of a possibility of a claim. So that's still the company's out.
Okay.
But if they can honestly answer that they don't know of any possibility of a claim, we can cover those prior acts, just in case it did happen, that they're not aware of yet.
Okay.
Okay?
Let me interject here because you guys are kind of like you're not an attorney, but you guys.
Sorry,
are
we
like
might be getting a little too ivory
legal
tower.
beagles. I think we got to wake up somebody. Wake up out there!
That's what you're here for, Jim.
Yes, exactly. But let's put it more in practical terms. So
Sure.
let's say that my brother-in-law decides to start a company, and he's selling used motorcycles, right? And he says, "Hey, Jim, you're probably the smartest guy in the world. Why don't you get on my board?" And Jim says, "Sure."
These are real hypotheticals.
I've heard that about
Yeah,
you.
real hypothetical. Yeah, real hypothetical.
And I went the other way.
Exactly. Why don't you get on the board? Oh, sure, I'll be on your board. And this guy is then, and I'm on the board, and we meet once in a while. And we're not in intimate details, and he's doing something wrong. He's paying his employees cash and not holding taxes or something. Is there sort of a difference between me being sort of like blissfully ignorant of the situation versus me saying, "Hey, why don't you do that?" That'll say and tell him the wrong thing. I guess I'm trying to ask the question: is there a difference between an innocent error and giving actually wrong or illegal advice?
I'm going to go the other route, mainly because it really doesn't matter, because you need the protection anyway.
Okay.
Because even if there's no malfeasance, or I hate to keep using legal words here, but even if there's no reason that they would think that they're doing anything wrong, if anybody else's perception that it is, they can sue.
Mm.
And where do you get the defense costs for that situation with, $25,000, $50,000? That's a drop in the bucket nowadays for anything that's going to go for any length of time.
So you almost need the coverage to pay for defense costs if the charge is false, but the director still has to defend themselves.
Correct.
Well, and Tom's right to kind of give a legal spin on that. Tom's right that anybody can sue anybody for anything, and you can. I've had clients spend a fair amount of money defending bogus lawsuits because it takes a while to get them thrown out of court. So even if we ask the question, is an innocent mistake going to be a problem? Well, if it's a truly innocent mistake and it doesn't rise to a violation of the law, then it's not going to be a problem. But if someone could still sue for it, but then there's the next level where it rises to negligence. Well, you may not have known it was a problem, but you should have known, and you had a duty to know, and you breached that duty by whatever action you took. And so people can sue the company for negligence, and oftentimes that won't arise to personal liability of the director. But then, and then the next level is actual intentional violations of the law. But you can get sued for all of it.
And this is why this coverage is so important to the father or brother that all of a sudden wants to do some good and join this group and try to give back something that maybe is, I keep thinking of, because I've been in a lot of sports boards, in my area when my kids were growing up. Not so much now, but you're doing something for good. You're volunteering. You're helping out whatever you're helping out for, and you're on this board. And if the coverage isn't right, there's nothing else that's going to protect you. This is a must-have policy if you're on a board.
Yeah, I imagine this makes a lot of sense for not-for-profits, because for-profit companies might say, I don't want to, we'll take the risk, I don't want to pay for insurance. They probably should if they're
And business owners are in the business of taking risks.
Yeah, but if you're on a board, you might as well protect your board members before, giving back to the community or whatever you're going to do. So that makes it
There's no reason to do it if you're not covered for this, because you're talking about your family's financial livelihood.
So you probably recommend that if someone's going to join a not-for-profit board, or the board of the Rotary Club or the Chamber or something like that, they should inquire and make sure that before they agree to join, ask what the insurance coverage is for
Yes, and
directors.
again, they should let somebody see it, because I've come across like Rotary Clubs. I look at a Rotary Club's policy. Well, it's only covering the board at the national level. And they keep showing each board member that comes in, well, we have this coverage. No, that's covering the national. It doesn't cover this individual board that you're on. I've had that happen to me in numerous cases with numerous groups.
So, Tom, thanks for sharing your information with us. If someone wants to reach you and get this policy, you do all sorts of insurance, right?
I do.
You've got a lot going on. What else do you do?
Well, I'm a speaker. I do train brokers. I'm a broker mentor. I have a consulting company. When a broker doesn't know how to do a particular type of an account, they can bring me in. I will be in the background if they like, or I will be like this with the broker selling the actual insurance with them when they meet their client. It just depends on what the broker wants my position to be. But first and foremost, I'm an insurance broker. And when it comes to property and casualty insurance, I specialize more in businesses than anything else, but high-valued homes and cars I do as well.
And if you're just listening on the podcast and not watching the video, Tom is a very sharply dressed broker. He's got,
Yes, he
got
is.
a race car
Yes, he
cufflinks
is.
and a little pocket
Yes.
scarf. It's very
Yes,
impressive.
let's get a close up of his cufflinks. Look at his race
like
car
those, huh?
cufflinks. See, look at that. That is, we don't have slouches on this show. We have top quality.
So how can
top
people
quality
reach you,
people.
Tom?
My phone number, which is my cell, is 708 254 8100. So 8100.
Okay. Jim, how
Okay.
can people reach you?
Reach me at 630-272-3895.
And
Kevin?
what the heck are you doing these days?
Well, I started something new. I'm offering also an insurance policy that protects families from financial difficulties should cancer strike. So it's a great program, and it's got a refund of premium aspect, and you should really talk to me about it.
And I'm Kevin O'Flaherty from O'Flaherty Law. We do just about everything legal related. You can call me for a free consultation at 630-324-6666. You can find more podcasts, video blogs, and articles on our website, seizeyourbusiness.com. Also check out my law blog, learn-about-law.com, and we've got a podcast for that too. I want to thank Tom Weiler from Weiler Studios for doing our videography. He does a great job. If you want to reach him for some video work, go to weilerstudios.com. And thanks so much for listening.
Thank you.